the honors of the court is, upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and we were told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge, in regard to capital offenses. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect to what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In any event, Your Worship, the practice directions of the principal judge and even Chief Justice cannot override the express provisions of the Constitution. We just wish to remind the court, and we are aware that the court is already aware, that the Constitution is the supreme law of the land. Your Worship, Article 2 of the Constitution is clear. Under the subheading Supremacy of the Constitution, states that the Constitution is the supreme law of Uganda and shall have binding force on all authorities and persons throughout Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions they pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Ebya, Senior Counsel, referred. We reiterate the prayer that 180 days have elapsed, and as the defense, we shall happily receive the conditions for the mandatory bail, because it is a command that it must be granted.
One of my colleagues will submit an authority after me, then Senior Counsel to close our presentation in this application. But I want to start with or just emphasize the practical matter. The date of remand and custody was 20th November 2024. Void General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. the state is aware of this fact because they have said so. In an affidavit before this honorable court, the state, through its detective IP or Benedict, they acknowledge that the respondents, namely the accused, were previously charged before the General Court Martial at Machinde. The application was filed on 5th March 2025, and it is the application for accessing the court records. Yes, the telephone particulars, which your honor is on this honorable court's record.
I think you want just to interject a bit. Allow me something.
I have not said the word and you're panicking.
Just speak actually.
Yes, you can't stop me before I say the thing.
You have.
Relax.
I hope you don't commit another crime.
No, it's fine.
So what I'm saying is that the document which my brother is referring to has not been taken down. And therefore, it cannot form. We cannot preempt a document in an application which has not been had and use it as evidence in your application.
Let him finish his
Your Honor, before I was rudely interrupted by the representative from the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001 of 2025, in which the number 01 2025, in which the state made reliance the affidavit of detective IP of Benedict, who saw that he's aware not only that the accused were charged before the General Court Martial, but that is also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your Honor, the plea for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial and detention is not too lengthy. Your duty as this honorable court is partly at Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is the effect that this court, office of the Director of Public Prosecution, and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of Besigye, Ebya, and Dennis. It should not be seen as to frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it involves you as the judicial officer presiding over this matter under that article to rein in the state and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months should be seen as inconsequential to the extent of that. And I say this in anticipation of some speech that may come after here relating to some practice directions, which are in fact a challenge of the are being challenged before the Constitutional Court. But even those guidelines themselves acknowledge that the Constitution comes first. At this juncture, my young brother who wanted to give us an opportunity to give this, then our closure will come through.
Your Worship, for purposes of record, I am true now. Your Worship, I want to join issue with my learned brothers who have submitted on the powers of this court to grant this person's mandatory leave, but only to add an authority for when court takes a view that the authority that was submitted is of an earlier date. Your Worship, I ask much of that. For if court takes a view that the authority that was submitted is of an earlier date, Your Worship, formally in 2022, the Honorable Justice Yaruhanga Jesse, sitting at Masini, the High Court, in Nyangoma Flavia versus Uganda, Nyangoma Flavia versus Uganda, in criminal application number 7 of 2022, at page 3, paragraph 4, had the opportunity to say this, and I will quote in verbatim. I have perused the lower court file copies of the lower court copies of the remand warrants and the applicants and 7 others. The remand warrants are to the effect that the accused persons were remanded first in prison on 12 November 2021, save for Kato Francis, A8, who was released on bail on account of being a juvenile. Since 12 November 2021, when the applicant and the 7 others were first remanded to prison, more than 180 days passed before the committal to the High Court. It follows, therefore, that neither the magistrate's court nor the court that has neither the magistrate's court nor this court has any discretion not to grant them bail. It was a violation of Article 23, Clause 6, Subclause C of the Constitution as amended for the magistrate before whom the accused persons first appeared after the expiration of the 180 days remand period to decline or refuse to release the accused persons on bail, for he or she had no discretion to do so. Your Worship, if I may add, is that such a decision of the High Court has a binding authority nature on this specific court. Your Worship, the Honorable Justice Jesse Yaruhanga took a view that the magistrate does not have discretion to deny an accused person who has appeared before him or her after the lapse of 180 days for avoidance of doubt, Your Worship. The accused persons were charged with murder, which is a capital offense, and only the tribal and the High Court. Your Worship, my comfort in that authority is to the extent that this decision is of similar nature as the case we are faced with today. And therefore, I reiterate the area prayers of my learned brothers that the accused persons are entitled to be released, and keyword entitled to be released on mandatory bail by this court. And this court has no discretion to deny such an application. Much obliged, Your Worship.
Please, Your Honor, I'll be brief, but before I advance my 2 points, I just want to tell my learned friend, the prosecutor, that it is unfortunate that he would refer to the previous incarceration of Aaron, whether in jest, knowing very well that it was before a lay court, because he said that he may once again be deported. It is not a fair thing to do, and cannot be taken in jest.
Can we create the way maybe?
Excuse me, please make way so that we can sit down.
Yes, it is.
I will just expressing regret that my learned friend would joke with liberty of our colleagues taken away illegally, as the Supreme Court found. But having said that, I want to commend my team. They have demonstrated to your honor the law of bail and the fact that the court has no discretion whatsoever. But we also want to refer you to one more case from the Supreme Court in the Foundation for Human Rights Initiative versus the Attorney General. Solicitor General, Constitutional Appeal number 3 of 2009.
Yes.
Katurebe CJ. Foundation for Human Rights Initiative versus the AG and SC. Constitutional Appeal number 3 of 2009. The decision is by Katurebe CJ, as he then was. He held that when an accused person applies for bail, the court retains the discretion whether or not to grant bail to the accused person, which discretion has to be exercised judicially. But now comes the most important. The only time when the court has no discretion is when a person has been on remand for the period stipulated in Article 23(6)(b) or 23(6)(c). In those situations, the court shall grant bail. I suppose the court retains the power to determine the terms of the bail. In other words, this is a Supreme Court decision, and this honorable court is obliged to follow not just the High Court, but the apex court decision. Now my 2 points. I want to refer you to the obvious, Article 126 of the Constitution of Uganda, which clearly states that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with values, norms, and aspirations of the people. In other words, the framers of the Constitution and the people of Uganda put the trust in judiciary to advocate on these matters. I am therefore urging Your Honor, in exercising your judicial power and in giving the ruling in this bail application, to abide by the values of constitutionalism and the rule of law, and in the name of the people of Uganda, grant our clients bail. My learned friend will be submitting on record on A3, but they have a similar history of detention, not exact the same period, but anybody who has finished more than 180 days, you are obliged to release them pending their committal. I'm also reminding the court of the obvious that the scales of justice must balance, and in Article 21, equality and freedom from discrimination, we come before you as parties with equality of arms. Therefore, the prosecution and the defense are equal before you. None is superior. And none should come with the assumption that they carry more weight. Therefore, it is your duty to demonstrate, because justice must not only be done, but must be seen to be done, that the scales of justice are balancing, and that you are availing all the parties, and in this case, A1 to A3, the due protection of law. And the law on bail is for their protection. So we urge you to exercise your discretion to give them bail on such terms as you find fit to enable these proceedings to continue when they are free, because they have stayed in custody for the maximum period allowed by law. I yield to my colleague, Speaker for the April.
Worship. First, I'm going to issue with the submissions of Senior Counsel Justice Kwago, Frederick Ipanga, Dr. Karua, Bitiisa, Brian. We contend that Captain Ola Dennis has been on demand exceeding the mandatory 180 days. Your Worship, Section 76 communicates to you and says that what happens when they present Ola to you after the elapse of the 180 days. You're only left with one option: to release Captain Ola. These are the situations where you cannot release Ola. If he has been committed to the High Court, Your Worship, Ola has not yet been committed. Or if it is in the public interest that Ola must not be released, Your Worship, there isn't any evidence that Ola is harmful to the public. Your Worship, then back to Article 126. Exercise of judicial power, which is derived from the people. Clause 2. In adjudicating cases of both civil and criminal nature, Your Worship, these cases of criminal nature, the courts shall subject the law, applying the following principles: that justice shall be done to all, irrespective of their social or economic status. My Lord, that Your Worship, Ola is a soldier. We pray that he also enjoys the liberty that is granted, couched in mandatory terms under Section 23(6)(c) of the Constitution. It also further says that justice shall not be delayed. The framers of this Constitution were privy to the fact that criminal prosecution is delayed. That's why they came out with a position that when an accused person is remanded exceeding 180 days, the choice is limited. And Your Worship, I'm appealing and praying for your choice. Maybe push me to the conditions that may be reasonable to grant Ola bail. Ola is a family man. The father, actually, he has children who have to go back to school. He's not sure that they'll go back to school because their father is here. That is Ola. Any other application to keep Ola in lawful custody, we submit that it is very absurd. In fact, Your Worship, we paying issue with the other submissions of the Senior Counsel. So,
We were not aware of the affidavit which was filed by the applicant. I don't know where the consciousness went because you have been serving each other. The prosecution has been making it a point to serve the defense each and everything that has been filed. That said, it is imperative, Your Worship, that you grant us 1 hour standover. We look through that affidavit and we make an informed response because we do not know what it contains. 1 hour to look through it because it seems to have a lot, and it would be just fair and just the prosecution for the respondent looks at it. Also, we haven't been my colleagues have been submitting and they have been keeping authorities to themselves. They are the people who are actually singing fairness, but they are acting not strong. Every authority that has been talked about has not been given this prosecution. We feel that is very unfair in that regard because we believe they prepared for this application. The fact that they put in an affidavit in support, they were prepared and therefore you are supposed to prepare all the authority and also grant us an opportunity to prepare our defense in this matter. There's an affidavit of proscopia. We haven't. And this is what we are asking for, that God gives us 1 hour, only 1 hour, because we operate as a team, the way they do. So we need an hour to look at that affidavit and we prepare our response. We are going to give it today, after an hour. And that is our point.
One, we are opposed to an adjournment for 1 hour. If he was talking of 10 minutes, 15 minutes, it would be okay. Because the only reference to that affidavit is to the date. A1 and A2 have been in custody from the 20th of November 2024. The contents of the affidavit were not part of this application. Because it's an application for bail. So if he wants to look at that paragraph, and I'm saying this because the court is aware that as senior counsel, I am coming from a neighboring country. I flew in today. I hope to go back later. We were in court last time. The prosecution opposed to us coming before the court the next morning. And then after I had left, brought the amended charges. If it's about fairness, let's treat each other fairly. The only thing mattering here is the date. Your Honor may give him 15 minutes to look at the affidavit. 1 hour is too much to ask.
Just to do the record.
Your Worship, before my colleague responds, the last time we were here, we called a jump so that we make this happen. The person who was present representing the state was Mr. Richard Girifu. So he's aware, because the court indicated we have done for your brother magistrate, because the presiding magistrate was not available, and it was made very clear that the application for mandatory bail will be made because the accused persons had spent more than money. So that was the 21st, we told the council. The other one about the authorities. All the authorities which have been cited are versus Uganda, whereby Mr. Billy Bumbuka, representing Uganda, is a party. So it means that by default, the office which sent him argues the cases, that they are not responsible to take stock of these authorities, and armed counsel, aware of what we're coming to do, cannot be taken on to their feet persons. He was aware we were coming to argue just that. And that is why court will note that when my non-colleague Mr. Alcantara asked that we proceed with application, he did not oppose because he was on notice. So his belated response, perhaps, is also courteous of counsel, probably when he's overwhelmed and concede that the circumstances are beyond him, so that court proceeds and pronounces this reform the conditions for mandatory bail. So we do not accept the 1 hour because my colleague was aware of what we were coming.
Your Worship, just like the Bible, with verses and scriptures, the Bible of justice is the Constitution, which Richard Bugingo has had for the time he has gone the law. And I do not think that an adjournment will have amendments to the articles in the Constitution. But the article is speaking in command that these people, F3, ought to be released. Unless Richard Bugingo is going to come and address court and inform that he's conceding that Richard Davis Ola goes home. If that is the question, I don't know. But if that's not the position, I oppose the adjournment of an hour.
Lastly and briefly, Mr. Bugingo Richard stated a lie to court when he stated that all the authorities that have been cited, he has not been given. Your Worship, he has an authority which I cited, it's even highlighted for him. So he's lying to court that all the authorities that have been stated have not been given to him, and I pray that he will withdraw that.
I think this is very simple. I take a notice that you have just submitted this. You have just don't we look so unfair? The rest of my senior colleagues, they can say I don't have any authority. For sure, you are not submitted. You are not given me. But nonetheless, maybe court can take a decision on that, and then we see, can get us.
So since the prosecution says that it needs to look at the affidavit, I'm going to give it strictly 10 minutes. So court is stood over for 10 minutes.
Besigye bayinza omutta atusabe kubanga koti bava gyongerayo for 10 minutes otegera bava gibuuza mbona ono birivumbuka ayagala kutunulako mu kipapula kino tebali mu kusoma so koti bagyongezayo only for 10 minutes so kitegeeza tetugenda kuvaako nyongera okubajjukiza nti omusajja ono aludde mu kkomera kirize tugaanye aludde mu kkomera Dr. Besigye ne Mume Obed aludde mu kkomera for now 6 months kitegeera ekintu ekyo kitegeeza balina okuvaamu mateeka kiri mu mateeka balina okuvaamu so bwe kyolina okukola okubeera kuno Kooti Media UD mwena abagiriko mu likinga video eyo kiyambe n'abalala okufuna information oba ogirayikinze kitegeeza omulala asobola okufuna chance nti ategeera kiki ekigenda mu maaso mu ggwanga mwena mugirayikinge muliko over 200 mwena mugirayikinge yambe Evans mwebale kuba nti Evans mwebale kuba nti ogoberera Evans Media oli wakabi nnyo. Thank you so much for always keeping it Extreme Media UD. If it's your first time here, don't go without subscribing. Make sure you subscribe and click in the notification bell. Obera updated ku buli kimu kikutuusaako omulungi agiriko ali abuuziza nti waliwo gwe basitudde mu kooti eri gwe basitudde mu kooti agudde munnamawulire azirise collapsing kankyogere bwe ntyo collapsed munamawulire collapsinze so ne bamufulumya. He's not going to read the paper, but he's going to make a call. Other office, the Anthony General, yeah, you may be right. Ongodia George, mwatu wagambye nti omusajja ayinza okuba agenda kuba simu ye Anthony General kiwanuka. Naye nga tubeereko tutuja yulu subscribing. Make sure you subscribe. If it's your first time here, please tuweze ba subscribers muchikole because and then those numbers ezili awo numbers ezili awo osobola oteekako data not supporting embeera yonna omulungi Mr. Billy Vumbuka yoyo sorry yoyo our state yoyo Billy Vumbuka yagenda okusomamu obawadde 10 minutes wanti somamu